Again, I'm Bart Ost, a member here at TAB. Been practicing law now for about 36 years. I'm with the law firm of Blythe and Ost. And as I was reviewing where we started last week, I was here to listen to Jim and participate in that great opening. And then looking at our speakers down the road, I realized immediately that the topic is so huge, trying to figure out what the intersection of law is with not only dying, but death, that it's just an overwhelming task to try to think about summarizing that in 20 or 30 minutes. So as I looked at the materials, I thought, well, maybe what I would do is I would narrow it down to a few things that may be closely connected to actually that part of the process that we call dying, and which has many forms and many words attached to it these days from a legal perspective. One is the right to die, one is dignity with death, and these words have become code words actually for much larger interaction of the public and national debate about what it is to be in a dying process and to have your wishes and your desires honored and respected and treated with dignity, especially by healthcare providers, by family members, by loved ones. And so I'd like to just sort of shape that conversation, start out with a little history. We're going to talk first about this right to die. It was actually something that was coined, began in the 1970s and 80s. It was initiated or sparked by a series of cases. These will be familiar to you, many of you possibly, and sparked really a national debate about what dying looks like to individuals and what rights attend to a person when they're in that painful situation. The first that you may remember is Karen Ann Quinlan. This is a case going all the way back to 1975. Karen came home from a party. She lived in New Jersey. She passed out. She not only lost consciousness, but her pulse she was basically without a pulse for a couple of times. Paramedics came. They resuscitated her and they brought her to a hospital, and she was hooked up to a ventilator. And she was on a ventilator for several months when the physicians reported to the family that more than likely Karen was in a persistent vegetative state from which she would never recover. The parents, and this will be important to our conversation, were Catholic, and they petitioned the local court to ask the healthcare facility where their daughter was being cared for to remove any life-prolonging mechanism, including the ventilator. And they did so because they did not want to be associated with anything that looked like, from their Catholic upbringing, euthanasia. But they felt that the use of a ventilator was a mechanical process that artificially prolonged their daughter's life, and they did not want that as part of their medical regime for their daughter. The Supreme Court of New Jersey eventually ruled in their favor in 1976. She was by the hospital, the ventilator was, she was removed from the ventilator, and to everyone's surprise, Karen began breathing on her own. Karen lived another 9 years. And not only that, but her family, her parents, demanded that the healthcare provider include as part of her regime all supplied nutrition and hydration for 9 years, but not a ventilator. Out of that, I'm told, and there are doctors here who can maybe help me out on this, but I'm told that there was a much more robust formation at that point from that decision forward on ethics committees, especially in the healthcare world, that started to look at this more carefully about the rights of a person as they ended the life. The next case is out of Missouri. This reached the Supreme Court of the United States. Nancy Cruzon. I don't know if you remember Nancy, but Nancy lost control of her vehicle. She was thrown from the car and landed face down in a water-filled ditch. She was without a pulse and unconscious when she was found by the paramedics, and the paramedics used techniques to resuscitate her. She was in a coma for about 3 weeks. And the doctors, again, much like our Karen Ann Quinlan, gave a report that Nancy was in a persistent vegetative state and she would not recover. Her parents asked the hospital to please discontinue any active treatment, including the provision of nutrition and hydration. It was resisted by the state of Missouri and eventually went up to the Supreme Court. And many may not remember that the Supreme Court, in its decision in 1990, sided with the state, but subject to some very important exceptions. One is the state had argued that Nancy had never given a statement or made a declaration about what should happen in the event she was incapacitated and needed special treatment. And Missouri said, without a clear and convincing statement from her, our duty as a state and our duty as healthcare workers is to keep someone alive, to protect that person. We don't make those kinds of end-of-life decisions. That's made by the patient. On the other hand, the Supreme Court said, guess what, state of Missouri? Every one of you has a right to, while competent, make a declaration regarding the extent of your health care at end of life. The family, after the Supreme Court decision, returned to Missouri and for 11 days gathered enough evidence to present then back to the trial court as to why they felt that their daughter had made a declaration about what she intended at death. The trial court agreed. The hospital was ordered to withdraw treatment, and within a few days, Nancy died. It's as a result of that case where states began proliferating with legislation that would allow for a written declaration to be made by every one of its citizens that proclaims to the world, in the event of something, this is what I would like to choose for health care treatment or not choose, and especially with end-of-life issues. And then the final case I'd like to talk about is a case that came up not long after that Supreme Court decision. It was right here in Indiana. And there was a lot of press about this. I remember it, my early years. And you remember Sue Ann Lawrence. Sue Ann was relatively healthy, but at 9 years old, she was diagnosed with a brain trauma. She suffered from this for many years, and in attempts to alleviate the problem, surgery was had, and on the last one at age 38, the results were disastrous. She came out of that in a persistent vegetative state. 4 years later, her parents petitioned a local court and said, we would like the nursing home where our daughter is being cared for to discontinue any active treatment, including artificially supplied nutrition and hydration. And the Supreme Court of Indiana eventually had to make a decision regarding her treatment. And they came away with some important holdings for our citizens here in Indiana and for each of you. The first is that artificial nutrition and artificial hydration is considered healthcare treatment that a person can accept or a person can refuse. More importantly, and secondly, the Supreme Court reaffirmed the common law that a person who is unable to make that decision, if you are unable to make that decision due to an incapacity, that decision can be made for you by one of your duly designated representatives. And three, I really love this part of the case. I reread it for today. The court went into a great deal of talk about why these kind of decisions do not belong as an interest of the state or in a court. They are to be determined by families. And it talked about the role of the family in the dying process and the sanctity of that family. But still recognizing the duty of physicians to keep people alive, the state to preserve life, and yet to respect the wishes, if articulated by a patient. So what are the takeaways? First of all, as an Indiana resident, each of you should know, you already do know, I am sure, that when it comes to a time to make decisions whereby you are competent to make those decisions in conversation with your physician, you make the decision. I will refuse life-prolonging treatment. I will accept the treatment you have suggested for me, even though it might be considered life-prolonging. You make the decision. And furthermore, that you can make decisions that might be considered by many to end your life prematurely. You've been diagnosed with a fatal disease. The doctor believes that death is imminent and suggests that you could be possibly cured by further medical treatments, maybe even use of life-prolonging treatment. And you have the right to say no to that. Or yes. Secondly, and this is where I think much of where we are with the right to die movement comes into play, and that is where you're incapacitated. You are no longer able to make that decision for your physician. And you have to figure out next, somebody has to figure out what happens. How many of you know of a document called a living will? Ever heard of a document called a living will? How many, you don't have to raise your hand, but I'm curious if you would, how many of you have executed a living will? Okay, that's good, that's great. Well, a living will is a document, very rare in Indiana, but it's a document that the legislature has actually provided not only an explanation about it, but provided a form. And the form is written out in the statute. And basically what it says is that if a doctor certifies in writing that you suffer from an incurable injury or disease and that death will occur within a short period of time, and that the use of life-prolonging mechanisms will artificially prolong your life, you may declare in that document that you do not want to receive certain kind of treatment. You do not want to receive nutrition and hydration, or you leave it to a decision of someone else that you've designated as your healthcare representative. This is a way to get through Cruzan, the Supreme Court decision, where someone needs to know what your intent was. This is a way for you to proclaim to the world in written form, this is how I feel about certain aspects of treatment I might receive that would I consider artificially prolonging my life. Now, who has heard of a life-prolonging declaration? How many of you have signed a life-prolonging declaration? Excellent. A life-prolonging declaration is the opposite of, and a form that is set right next to the living will. And it basically says, in the event of the same circumstances described in my living will, I would like representatives of healthcare providers to use all efforts, every effort that are at hand and available to keep my life going. Now, in my years of practice, I've had one person do that. I've had more people walk away from my office not wanting to fill out the form because they do not want to face what that might mean for them than those who have selected one or the other. So it's a very critical document. It's a document you can review with your attorney. I will tell you right now that if you take that document out of the statute, it will be a poor document for you. In fact, the statute recognized that. The statute said, you know, you can modify this form. I'll give you two examples of why that's the case. First of all, the form says that I have a choice of either accepting artificial nutrition and hydration or declining. It doesn't break them apart. I have more clients come to my office who say, whoa, I would like to have some hydration if you don't mind. But the nutrition part of it that keeps me alive, I believe, is artificial for what I'm going through. So they want to make an alternative selection. That's not available with that statute. You need to modify it. So it's critical that these documents be looked at. You'll also note that in my description of the living will, it says that if my doctor certifies in writing that my death will occur within a short period of time. So where does persistent vegetative state fit? It does not. Because that doctor cannot certify that your death will occur within a short period of time. In fact, you may live, as we've seen, for years. So that document needs to be discussed with your attorney. It cannot stand alone. If you find forms out there in the world, on the internet, and you use them indiscriminately without knowing some of these things, you could actually not be utilizing the full capacity of your rights that you're entitled to. Okay? All right. There is very quickly an opportunity, recent legislative, I'd love to have doctors respond to this, but its acronym is POST, POST. It's a physician-ordered scope of treatment. I don't know if any of the doctors here have used them. This is a doctor-client, doctor-patient document. The lawyers don't get involved in it. We don't frame it. We don't participate in it. We receive it for our file and make sure it gets to the right places. But it assures you as a patient that you have had a long conversation with your doctor because you are in a situation where you have a chronic illness or injury that which death is considered to be imminent, whereby you and the doctor in a refined way, in a more clarifying way, go through a lot of different aspects of what your treatment might look like down the road and what you would select and not select. The living will is a blunt instrument, to tell you the truth. It talks about one thing, artificial nutrition and hydration. It sort of gives a sense that I don't want a lot of extra stuff. But these post documents can get you really, especially if you have time and you're mentally aware, but you know that you're suffering from a disease that may be relentless, it's good to have that conversation. Keep it in your mind as something that you can utilize or give as advice to friends who may be going through that. The last takeaway I have is appoint a healthcare representative. You have a living will. It says something. Why do I need a healthcare representative or a healthcare power of attorney? Well, I'll just tell you, I'm not going to go through it. The forms are long, but they are robust. They give your agent so much clarity and power to do things that you would want them to do. But most importantly, we do it because there's a model act that we've adopted called the Healthcare Consent Act. And in it, there's a ranking of priority of who can make decisions for you if you no longer are able to do so about your health care. And what's at the top of the list? A healthcare representative or a healthcare power of attorney. If you walk into a doctor's office with that document, and you're immediately then considered the person who that doctor will consult with and will look to for final decisions. It's a powerful document. It can be one person or more. But it's your opportunity to have designated someone that you've had discussions with. That's what we talk about. Why don't we talk about death and dying? Because so much of what I'm talking about needs discussion. So that your wishes, the dignity you desire and insist upon, will be respected at death in the unfortunate event that you can no longer make those decisions while death is waiting on you. And so the second rung is a guardian. Someone can go and get a guardian. If you don't have a healthcare representative, someone can get a guardian. Who's third in line? Spouse, children, if you have parents, and then siblings. That's it. But they're at the bottom of the list. Why is that? Well, I'm going to tell you my theory on that. It's because if you slip down to that third rung, or even at the second rung, you're usually in a controversy. And it's been created because you've not designated someone. Let's say that your spouse, it's a second marriage, the children of the first marriage are not, first of all, either getting access to healthcare decision making, or they disagree with the position being taken. What if the children are not all of the same mind? Maybe not the same faith backgrounds. Maybe they don't come with the same values. Both legitimate on either side, but have disagreements on how to proceed. If you can have that conversation beforehand, and you can appoint who you want, and you've talked to them, and you've talked to the other family members, and you've talked around why these are important decisions and why you've come to these decisions, it's a boon for you. It's a great step forward. Okay. So now I have to go into overdrive. Let me give you a few more bits of the intersection of law and this topic, especially as it concerns dying. I'm going to talk about an out-of-hospital do not resuscitate order. I don't know if you've ever heard of it, but you all heard probably of do not resuscitates, DNRs or codes that can be obtained in a healthcare facility or at a hospital. They're usually done by doctor certification about your condition. Death is probably imminent, and there's been a designation that you are not to be resuscitated because you're in a healthcare facility where your instructions, which are guaranteed, are going to be followed. Now, what if you are in a position where you are not in a hospital? Let's face it, although that's the way it was for many years, let's face it, for hundreds of years, where did we die? I mean, we died in the home. Only relatively recently do we find more and more people being cared for in institutional settings, especially in nursing homes, long-term health care, perhaps in a persistent vegetative state even. But many, many people crave to have their last moments in their home. And families will go to all efforts to make that available. Hospice will be available in your home. What you don't want to have happen is a call from, say, that I received from my brother, saying, I'm here at the hospital. Mom, as you know, wanted to die. She was at home, and I called because seemed to me she was under such agitation and pain. Her breathing was labored. And the paramedics came, and I said, do we have to do anything? And they said they did. They're required by law to resuscitate her, and they brought her to a hospital. And her pulse ended, and my brother said, I'll just come out. And they used pads to bring her back to life. Now, that was not my mom's wish. I know that. But since she was at home, she didn't have an opportunity to make a declaration like we do today, this out of hospital, do not resuscitate. It's a written document. An attorney will discuss it with you. You have it by the bedside. You have it in the medical chart. If paramedics come, if you have a healthcare aide who's working there, they know that they are not assuming any personal liability if they respect that document because they see it. HIPAA, just one quick note. HIPAA, of course, is the Health Insurance Portability and Accountability Act. You most often come into it because you go in and you say, I'd like to see the records, healthcare records for my wife, and they look at you and say, well, sorry about that. You wonder, why am I not getting permission to get to my own wife's medical records? Well, because of privacy concerns, now every individual is sort of standalone unless there's permission to access. I only say this and bring this up because those kind of rights to access your records need to be in these documents. They need to be in your healthcare power of attorney so that your healthcare power of attorney can get to those documents. They need to be in your will so your personal representative, if there needs to be any investigation of any sort, can get to those documents without any further review by a court or otherwise. Anatomical gift. Here's one that probably you haven't thought of before. Most of you think that if I choose to make an anatomical gift, I know sort of how to do that. I can go to the Bureau of Motor Vehicles, or I can go to a registry, an Indiana registry somewhere, and I can make a gift of a part of my body or my body to education, research, etc. If I don't do that, and you don't find that anywhere, I bet your presumption is, well, okay, that's my statement to the world about how I feel about it. If you become mentally incapacitated or even at death, I bet you don't know that part of the powers of a healthcare power of attorney are to authorize making use of your body as a gift or donation. In fact, if you don't have that healthcare power of attorney with that power, the next person who can do that is your spouse. And your children can do it, and your parents can do it, and your siblings can do it, and guess what the next one is? Your next of kin. It just seems to never end. And so the bottom line is that you could have part of your body donated, even though you had thought that would never happen and you didn't actually want it. I raise that because today, now, part of what an attorney will do is to make sure that you have a declaration one way or another. No assumption. You have a declaration that you are going to, or maybe if not, then you declare you are not going to do that. A quick on the financial power of attorney. And death. My stories are all sad with my parents, I'm sorry to say. They were great parents, but my brother called me again. My brother was the primary health care giver with my dad as well. He called me and from our home in New York. He was living with Dad and said, Dad just does not look good. He's not acting right. He's gaunt. I don't know what to do. I was there the next day. And I saw my father in a way that I've never seen him before. In fact, I did not recognize my father. And it soon became apparent to me that my father did not recognize me. And I had no opportunity to prepare for this. I walked into the room, and that happened to me immediately. And we took him to a hospital. Eventually, after many tests, he was diagnosed with a massive brain tumor. It had erased basically all of his cognitive abilities. And by the time he was in the room, he was in a persistent vegetative state. virtually. But the doctor said, there are still opportunities with aggressive treatment. We might do something, but I give it no chance whatsoever. We didn't know a thing about my dad's desire for prolonged healthcare treatment. The best that we could come up with, 3 children sitting there, the best we'd come up with was a statement that he said, and this was we really had to go far to go from there to here, was, when I die, Bart, Brad, Randy, you promise me that you're going to put me in a pine box that's as cheap as you can find. And it was always in humor, but it was always linked to this better idea that if you could walk out in the woods, we lived on wooded property in the middle of the forest, in the middle of if you can go out and actually cut something down and get it done and put me up by Kitty with a stone on it, that's even better. So, from that we sort of extrapolated that he would not want, he considered the body at that point done. He was gone. He knew where he was going. But I talk about a financial power of attorney because when he became incapacitated, the doctor could not tell us that death would be imminent in a short time. I could not access my father's financial affairs. I did not find a power of attorney, a simple, relatively simple document. So while I wanted to focus at this time on my dad and his health care, I was forced to go out and look for an attorney who specialized in guardianship law in New York, get the petition filed, and have a hearing set that wasn't for several weeks down the road. And here I'm sitting wondering if Dad's investments, what's happening with them, how do I pay his bills, and I'm stuck. And he's in a coma. My dad died, wouldn't you know it, just a few days before the guardianship hearing. So for all that effort and all that expense, it was for naught. But you could be seriously hampered. Okay, I have a few more, but I'm going to now, since I'm out of time, I'm going to race ahead to the conclusion here. And I want to talk to you a little bit about the role of the attorney in the dying process. And I consider it to be how do I put it? Something special that our profession enables us to do. Jim does a lot of estate planning, and it's just a rare opportunity to be linked with people who are thinking about the most important things in their life and knowing that you're helping them prepare for that. So my story is about 2 such people, and their names are Ruth and Mabel. Mabel, also known as Meg. They were sisters. They were probably 2 degrees separated from my wife biologically, but I always would see Ruth, especially at family get-togethers. Meg had this dream job. She was a teacher of English in a French school in Paris on an island in the middle of the Seine River. I mean, how do you get that? They had a younger sister, Alice, who lived in California, and a brother who had died. Ruth her husband had predeceased her by a number of years. They'd not had any children. And at age 75, Ruth called me, and she's in tears, anxiety-ridden, and she said, Bart, I am so stupid. I am so stupid. She said, a young man came to the door. I let him in. He said he had something he wanted to show me that would make my life happier. And it was a giant machine that would clean carpet and would wash my carpet. And I listened to him for a while, and then I tried to politely say, I'm not interested, and he continued to pursue. And I tried, and he pursued, and she said, I finally felt that the only way I could get rid of him is if I would buy the machine. I bought this many $1,000 machine, Bart, and I gave him a check for the down payment. What can I do? Well, we got our money back. We got our contract terminated. We turned him in to the Better Business Bureau and to the Consumer Affairs Division of the Secretary of State. But that was my entry into working with Ruth. She was 75. Her sister comes home from Paris, and when they're both in their 80s, and she's remarried, or married for the first time, an older gentleman who subsequently dies, childless, and decides she wants to move back with Ruth. And they find this gigantic apartment at Marquette Manor. And they called me up and they said, Bart, would you help us negotiate the terms of our agreement there? So I came over and we got them moved into Marquette Manor. And then eventually they called me up and said, Bart, would you come over? We would both like you to handle our estate planning. And I came over and we spent weeks and we came up with all the documents that you would ordinarily need, including healthcare power of attorney, healthcare representatives, living will, trust, other documents that are essential so they could say that they had sort of settled their affairs. They put their affairs in order, as it's often said. Well, at 89, Meg died. And Ruth was visited by her sister from California. And Ruth is about 86. And Ruth and Alice said to me, Bart, Ruth can't really handle her financial affairs anymore. Can you step in? Ruth is clear as a bell. She's mentally, but for various reasons, she just was not able to do that any longer. And I said, sure, but I said, I have a condition. I said, I will only do this if, Alice, you serve alongside me as co-POA so that I can have someone from the family overseeing everything I'm doing. At 89, I began meeting with Ruth Canaline every month. I would bring her, first I would prepare a report and send it to Alice, and I would call Alice and talk about what I'm going to share with her sister. And then I would sit down with Ruth, and I would go through the bank statements and how I reconcile them from the month to month. I'd go through all the bills and what I paid and why I paid them. She had investments, and they were out of an investment advisor from Arizona, and I would prearrange for a telephone conference call. And we would call the investment advisor up, and we'd have a long conversation. Well, that lasted for many years. And during that time, there were some other services. There was the infamous bathtub, water cascading over the side, going down from the 3rd floor to the apartment on the 2nd floor to the apartment on the 1st floor. And it was not so much dealing with that as it was dealing with Marquette Manor coming to me saying, I'm not sure she can really stay in that location. She may need more assistance than she's getting. We moved through that, fortunately, and she stayed. I'd also worked out a deal whereby all of Meg's personal property stayed with Ruth. All the heirs agreed, let Ruth enjoy what was in there. And so there was a lost hearing aid within weeks after buying one. We had to work through that. Other things that just required further attention. So I'm doing this month by month into her 90s, and one day I wake up and there's a 100th birthday for her. 40 or 50 people are invited, and Ruth is clear. She, in the last couple of years, had been calling me periodically, and she, in her very soft voice, but direct, she said, Bart, do I have enough money still to stay at Marquette Manor throughout my life? And I would chuckle, and I'd say, no, remind you, I'm going to be meeting with you, and yes, you do. And then I would call Alice, and Alice would call, and I would learn that that was fine. Or more likely, she would call me and say, Bart, did we remember to put so-and-so as a gift to so-and-so in my will? And I would then bring the will out to her and show her what she had done. So at 100, a letter was read from a man who had just retired, a PhD in music. Choral music was his specialty, had written many choral pieces, and taught for years. And on a whim, after retirement, apparently after the first few days of golf, finding nothing else to do, he decided to inspect the web, search the web to see if he could find the person that was most influential that led him to his life in music. And who do you think that was? Ruth. How did he find her? Because we had posted on the internet her 100th birthday celebration, and he had just found out about it. And he wrote this letter describing to Ruth how much he had been impacted by her teaching. She's 100 and he's retired. Well, Ruth's condition precipitously dropped after the party. I received a call from Marquette Manor that she'd been taken to the hospital. I called Alice. Immediately I found out where she was, what the nurse's station was, where she was being cared for. I delivered all her important documents, including her living will, her healthcare power of attorney, and contact information. She stayed there for about a week and came back in a persistent vegetative state. We arranged for hospice care. Her sister came in from California, and she was moved to the rehab center at Marquette Manor. where eventually she died within just a few weeks. The celebration was magnificent. We met with the family afterwards. They already knew everything that I had done. They knew who the personal representatives were going to be. The first thing I did when they were appointed, one from California, one from Georgia, without either one of them having to come, I got them appointed through the court here, is I sent to the nephew, who was the co-personal representative, about 15 years of monthly reports and statements. It was a huge stack, just to assure him that every step of the way on this process, I had been diligent in making sure that her situation had been properly overseen. We got the estate finally settled, and I realized that over a quarter of a century, I had been privileged as really part of God-directed activity to be an important source for her of trust and confidence. And why do I bring this story up? Well, I'm going to tell you why. It's Love Your Attorney Day. I'm going to tell you truly here, I think I gave her the thing that I'm going to want at my death in terms of estate planning, and that is two things. The first is, I felt that she at all times, because of the way in which I interacted with her and the way in which I did things and the which way I explained to her and created her documents, that she had a level of confidence and trust, that she knew that she could call me first to get a correct answer to something that bothered her. And secondly, that at the end of life, it was not a burden. It was not on her something that she had to think through a second time, or maybe catch up, or maybe do from scratch. The idea of, did I pack my bags early, or did I wait to the last minute? She had enough to deal with without thinking on that. The second is, I hear this often, and that is families will come and they'll say, or just a client, you know, I don't want to be a burden on my family when I die. You know, it's kind of a funny thing. I never consider it to be a burden to respect someone at death and to go through what they, with their family, what needs to be done. And what's neat about having a relationship with an attorney who does these things for you beforehand is that the family, when they're exposed to and know what the attorney has done and have confidence in that, they can then attend to the more important things that come with end of life. The meaningful conversations, conversations with physicians, with healthcare providers. They don't have to worry about whether that particular document that they're going to need has been signed, or is it available, or where is it, or who's supposed to have it. So I'm going to encourage you that part of this death and dying and the interaction, the intersection of law, you're going to see laws. I've got a book of laws. I mean, you can go read them, but they won't help you unless you probably have a guide, a counselor, someone that you respect, someone that come alongside you, and maybe for a long time, maybe for a short time. And if you don't have an attorney, I suggest you find one and you get your affairs in order, because it's important, and there are rights that you are not protecting if you don't do that. And you're creating an unsettledness at the end that can be avoided, and where other more important things can take place. And then John slipped me a piece of paper. Where is it, John? Something about remembering what? Remembering tab in your will, I think it was, something like that. That's not from me, it's from John, but I did it as requested. Okay, so we've got some time left for questions. Yes?
I have a very stubborn mother who's almost 84, and she absolutely refuses to sign anything, to discuss anything. She says, it's no big deal, I live solely on you girls and Social Security, there's nothing for me to worry about. My mom refuses to go to doctors.
Right.
And she's getting sick more frequently, and each time it's harder and harder. Do my sisters and I have any legal ability? She's of sound mind.
Right. And remember,
Can you kind of repeat the
let me repeat the question. I have a mom who avoids the idea of going to an attorney to get documents or affairs settled. She does not like going to a doctor. She's ailing, but she's mentally fit. What rights do I have and my sisters to work with Mom to make sure that important things happen for her? I want to make a couple of, and I hope I'm not pushing back here on you at all, because this is obviously can be a painful feeling. But I want you to recognize that probably the hardest thing for family members to recognize at times is that their mom and dad have rights. You may not like the way they're exercised. They may be a pattern that you've seen in life and you've just never agreed with, but they have rights. Secondly, yes, you have certain rights that an attorney can go through with you. One of the ones I talked about today was this healthcare consent law. If she lapses and can no longer make healthcare decisions on her own, you're on that bottom rung, but you're still on a very good rung. As long as everybody's sort of on the same page, you can all make healthcare decisions for her, and you can make some of those important decisions. I would try to have conversations about it with her. If she won't go to somebody else to talk about them privately, if you can maybe at least get something out of her that says how she wants to be treated at death, you can then communicate that and say, I had a conversation, and she said this about healthcare treatment. Maybe she won't sign anything, but if she can tell you, then maybe you can carry that message on if she can't. Guardianship is not an opportunity because she is mentally competent. We only can appoint a guardian for someone who's mentally incapacitated. So that's not available. I've had clients that are difficult, resist, and you deal with it as you can, but I recognize that deep feeling of unsettledness that comes with it, and I don't know if that answers enough of the question for you or not. I hope everything gets better there. Yeah. Well, and I don't mean to make it sound, you know. Okay. All right. Anybody else? Yes.
What's the average cost of having a will or having all these things done up, just from a practical standpoint? A range of...
Sure. You know, the estate planning conference today, my initial conference is 90 minutes long, and invariably clients will step up from the desk when I say time's up, and they'll go, where has the time gone? It has been engrossing, it's been encouraging, it's been interesting. And they go home with homework. So it is not something you try to go in and see what the flat fee is for a simple will for $50 or find something online to do. You need to have a conversation. Attorneys have different rates. You will have to find an attorney with a rate that agrees with you, but you could easily spend hundreds of dollars in getting all the documents that you need and getting all the advice that you need and the next steps in place. And just, I would encourage you to look to referrals, look to other people who have gone through the process, have them share with you how they felt about it, what the cost was. It depends so much on what you want to do. Some people will go to great lengths to do some significant estate planning, which requires multiple trusts and various other documents that are far beyond what maybe some other people might have. So the range can be hundreds of dollars to thousands of dollars. The nice thing that you should know is that when you walk into an attorney's office, you tell the attorney, I'm just here to seek consultation about why I might retain you. And one of the important things I like to talk about is your fee. And why I like your question is because one of the things I do with my clients up front is I say, you're not leaving here until I tell you what I think the cost is going to be. And you make the decision. And if that is too much, I understand. And I'd be glad to give you names of other attorneys. I don't know what they'll charge, but I can give you other people that I respect in the estate planning world. Does that help you at all? Yes?
Am I hearing that the spouse does not have first in line for health care decisions?
So, attorneys invariably say something, and then there's always, from another attorney, except Bart or but Bart, and you're doing exactly that. I've covered so superficially so many of these subject matters. The idea that the spouse is third in line doesn't mean that the spouse can't be catapulted first by being designated the healthcare representative. So if you're married, most often I find the other spouse is what? The first person designated as the healthcare representative. Now, you and your spouse may be of similar age and fighting the same kinds of things that come with declining age, and you say, well, that's not going to do it. We better have a backup, better have somebody else there. And so you may select children or, you know, who knows what after that point. But the spouse is going to have significant rights if we go forward with appointing that person as a healthcare representative. Okay?
But it has to be officially
Yeah,
appointed.
it's got to be in writing. It has to be executed in conformity with law. Correct. In the back?
Is it legitimate to ask if you have a list of the documents and forms that you described to us today? That a person
Most of that stuff is very secret. It rarely gets out. In fact, you can go on the internet, and if you can find something, it's impossible. I mean, I didn't mean to be. Yes, there are lists that I can provide of the documents that you would probably need as a primary source of information. You know, in terms of this dying process, you're probably looking at a living will, modified. You're looking at a healthcare representative or a healthcare power of attorney. You're looking at a financial power of attorney. You're looking possibly at out of hospital do not resuscitate. You're looking at documents that deal with your anatomical wishes regarding anatomical gifts. Funeral declaration. There are a number of documents, but it's not the form. It's the content behind the form, the discussions that you have, and then what you have outside of that attorney's office. A quick note about burial. I sort of think, seeing I have time, I just want, because it's an important part of it. I was just at my brother's home in Atlanta celebrating his son's first birthday, and with us was his mother-in-law. His mother-in-law's father had died, a military man who was honored by being buried in the National Cemetery in Washington with full rights, and it was an impressive ceremony. And she and her sister are there, and apparently he had been cremated and there was an urn. And apparently that urn was going to be immured somewhere there on the grounds. And it came in a part where the mother-in-law said, they handed the urn to my sister because there was going to be some ceremony. And my sister whispered to me, you know, I've changed my mind. I don't think I can have the urn anywhere but with me. And here we are, you know, all the way at the end. And siblings are not on the same page. Funerals can be like that. We've had an unfortunate case come up in Indiana about who has the authority to say where mom and dad or a loved one is buried. Unfortunately, because of that, we need to be in a position where you make certain declarations about how is your body disposed of? Where do you want to be buried? And make sure that someone's appointed to make those decisions and have the authority to make those decisions. Anybody else? Wow, that's great. Answered every one of your questions in 55 minutes. Thank you very much. Appreciate it.